Tesla shareholders voted to approve Elon Musk's pay package and to move the corporation to Texas from Delaware. Joining us now to talk about the legal hurdles that Musk might face to make the pay package a reality, Ann Lipton, associate professor in business law and entrepreneurship at Tulane. Good morning. We've been speaking about this with you now for several months as this has progressed. Were you surprised by the outcome of the vote?
Not really. I mean, I think most people, up until very recently, most people were predicting that the package would be approved. So I don't suppose it's surprising. I'm a little surprised, I guess, by the vote in Texas. I thought there might be a little bit more opposition, but in fact, more shareholders voted for that move than voted for the pay package.
So given how apparently overwhelming the vote has been, how do you see a judge in Delaware viewing this entire situation? Is this now a moot issue, or do you think that it's much more complicated?
I think it's much more complicated. Overwhelming, actually, the numbers are hilarious. They just came out. The numbers are almost identical to what they were in 2018. 72% voted in favor, 73% in 2018. But I think that there are more legal hurdles. I mean, like, on the one hand, I think that there is a sort of, emotional component. The shareholders voted again. She said the first time that they were misled, and now, having seen her full opinion, they voted again in favor of it. And I think that does carry like emotional and rhetorical weight. But I think there are also strong legal arguments that this vote was strong-armed, or that it's not particularly economically productive to Tesla in light of the fact that they might give a new pay package to him, very likely will. I think those arguments still have weight, and we'll have to see how it plays out.
But am I misunderstanding? I've read this decision now many, many times, and the central component of the decision that has the most weight, I think, was about the disclosure issues, was about the process, was about the idea that the shareholder was somehow hoodwinked at the time into believing that the deal was, in fact, done at arm's length, and her argument was that it was not. And that once that issue is taken off the table, the other issues that you are raising become much harder to defend, no?
Well, I think that her original decision actually had two components. That was one big part of it. But another really big part of it was how close the ties were between the directors and Elon Musk. And it's very hard to get rid of that, even though we have this new special committee of one who said that she was not going to revisit the original decision of the original committee. So I
need to stop you, and I apologize, because I think we're either talking past each other or we're misunderstanding the situation. The secondary issue was the close ties. I agree with you about the board, but the issue that was raised was therefore about disclosure or an understanding that there were these ties. And what I'm saying to you is, given what has now been exposed, available for shareholders to see about the close ties, right? All the shareholders got to read about how close the ties were, how they all might be together in cahoots, whatever you want to say. And so now that you know that and you vote in favor of that, I'm trying to understand how that unto itself is now still an issue in this context. You could still debate whether the governance at this company is appropriate. We can have that discussion. That's different than this particular issue.
Because both components are really important to the decision. It really wasn't just about disclosure. Additionally, it is not 2018. It is 2024. So then we have to ask, was this set of proxy disclosures about why the pay package is being given in 2024 sufficient? So now, even if with full disclosure about what happened in 2018, it's not 2018 anymore. So now we have all kinds of questions like, if he doesn't get the pay package, does he take artificial intelligence to other companies? If he doesn't get the pay package, there was a suggestion he would leave, but that wasn't clear. So do shareholders know that what they're even voting on? So now we have this additional set of issues about the process by which this vote unfolded, coupled with the original taint of the close ties of the directors to the original pay package. And that can't go away as easily.
I just don't understand, given that this was about as open a book as you can imagine. Like, we all saw it, we all knew it. Yeah, we've heard about AI this and AI that, and is he going to go do this or do that? But that was out in the public too, frankly.
Because being in the public, it wasn't really. I don't think it was much of an issue in 2018. But I mean, the issue here is that we don't leave it solely to shareholder voting alone when there's reason to think that that there's going to be retaliation from a powerful controlling shareholder. And that part of it hasn't gone away yet. So that's why the shareholder vote alone can't ratify the pay package.
So it sounds like if you were the judge, Ann, you would strike this decision down.
I do not know what I would do if I was the judge, and I'm not making a prediction of what she's going to do, but I do think that there is a long legal road ahead.
Let me ask you a question we were talking to Jay Clayton about earlier. If you're the lawyer who brought this case, and in fact the vote is accepted by a Delaware court, he is asking to be paid effectively for trying to create value for Tesla shareholders. You could argue, if in fact the vote is accepted, that he not only didn't create value for the shareholder, that he created negative value for the shareholder in terms of additional costs. How much would you pay said lawyer?
I won't put a number, but I can tell you what the issue will be in that situation. Delaware recognizes the concept of a therapeutic benefit. By improving corporate governance at a company, you have provided a benefit. Even if it's an expensive process, you've corrected a problem with the way that the corporation went about doing things, and that is worth a fee. So in this case, by forcing them to go through the process, what they forced them to do was adopt, if the court so holds, proper process. And that's valuable and it's worth something. It's not worth the same thing as if they had gotten rid of the entire pay package, but it is worth something. So it doesn't mean they don't get any fee, but probably a reduced fee.